This meeting to order. I want to welcome everyone to meeting number 14 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 1083H and the motion adopted by the committee on Wednesday, September 17th, 2025, the committee is resuming its review of the Conflict of Interest Act, and I'd like to welcome our witnesses for today. As individuals online, we've got Mr. Andrew Stark, who is a professor of political science at the University of Toronto, and David McLaughlin. Professor Stark, I want to welcome you to committee. You have up to 5 minutes to address the committee. Go ahead, sir.
Thank you very much, and thank you for inviting me to appear before the committee. I want to note, just in the interest of full disclosure, that 40 years ago, I worked in Brian Mulroney's Prime Minister's office as the assistant to Dalton Camp, who was then Mr. Mulroney's senior advisor, and I believe if it's the same David McLaughlin, that David McLaughlin was a friend and a colleague of mine at that time, and I haven't seen him since. So it's a pleasure to be reunited if it's the right fella. I've had no partisan involvement since well before the Progressive Conservative Party disappeared over 20 years ago, and I'm here as an academic. Partly because of my background, though, I want to make a brief opening statement, not about the law of conflict of interest, but about the politics of conflict of interest. So suppose that we know that an office holder has been influenced in their official conduct by a personal interest that they have. We have actual evidence, maybe through emails they wrote or comments they made to a third party, that their judgment was tainted. That's not a conflict of interest. That's corruption. Their judgment in office was corrupted because it was influenced by the personal stake they had in the matter. A conflict of interest arises when an official is merely in a position to do something in office that affects their interests. They may well be a person of sufficient integrity that they will rise above and totally ignore those interests in their actual decision-making. The problem is that we can never rummage through an official's mind and know for sure that their judgment was unimpaired by their interests. And so we say to officials, don't even raise the question as to whether your judgment was impaired, because that question is unanswerable. Arrange your affairs so that you aren't even in a position where your interests could affect your judgment. Being in a conflict of interest is thus a serious matter, but it is not necessarily corruption. Conflict of interest law is prophylactic law. It doesn't prohibit wrongdoing. It prohibits officials from being in a position where they could do something wrong. And it does so because any actual wrong would take place in the mind of the office holder, a place we can never access. In a way, it's a misnomer to call the conflict of interest laws ethics laws, because an official can violate conflict of interest law and still be a person of complete integrity. Unfortunately, both politicians who get into conflicts of interest and their critics often misunderstand this. A minister who finds himself in a conflict of interest will defensively and indignantly believe that he's being accused of some kind of corruption, and so will angrily deny that he's in any kind of conflict of interest. That doesn't follow. Maybe his judgment wasn't corrupted at all. Maybe he feels absolutely certain in his own mind that it wasn't, but he could still have been in a conflict of interest if he was in a position where it could have been corrupted. His opposition critics, meanwhile, will suggest that because he was in a conflict of interest, he has done something corrupt. That doesn't follow either. Just because we know a minister was in a conflict of interest doesn't mean anything one way or another about whether his judgment was actually corrupted. For his critics, then, the fact that a minister was in a conflict of interest means that he is corrupt. For the minister, his certainty that he is not corrupt means that he couldn't have even been in a conflict of interest. Both sides mistakenly equate conflict of interest with corruption, and so we get consumed with unnecessarily overheated conflict of interest controversies when there are so many more important things on the public agenda. Let me close with a model of how conflicts of interest should be handled politically, in my view. In October 2003, Canada's Labour Minister, Claudette Bradshaw, announced that she had inadvertently violated federal conflict of interest rules. She had accepted free travel from the Irving family of New Brunswick. As soon as it came to her attention that doing so was prohibited, she took action to reimburse the Irvings, acknowledged that she had fallen afoul of the rules, and apologized. I apologize to the House, she said, and I apologize to all Canadians. Opposition leader Stephen Harper then responded simply that Claudette Bradshaw did the honorable thing. That was it. The matter was closed. Both Ms. Bradshaw and Mr. Harper handled the affair appropriately. Everybody moved on. That, I believe, is a model of how conflict of interest controversies can and should be handled politically. Thank you.
Okay, thank you, Mr. Stark. And Mr. McLaughlin, if you'd like to, you can address the committee up to 5 minutes, sir. Go ahead.
Sure. No formal opening statement. I just, again, apologies for running behind. I went to the wrong entrance. So if you do need some extra time from me at the end, I'm happy to stay a little longer to make that up for you. I am no expert on conflict of interest or the state of federal law on that. I have no academic or particular expertise in that area. I have been in government and at the federal and the provincial level. I ran a Democratic Reform Commission in New Brunswick as a deputy minister. I was clerk of the Executive Council and Cabinet Secretary in Manitoba. I've been chief of staff in both the Prime Minister's office, Minister of Finance's office. So I have seen things of governance, if you will, from various perspectives. So if there's some general background or knowledge that I can help you with, I'm happy to do it. I believe very strongly in the importance of our democratic institutions and frankly, very much in the work that you do. And I feel an obligation to try to assist you in any particular way that I can. So I'll leave it at that. And hello, Andy. And we'll happy to take any questions you might have.
All right. Well, thank you, Mr. McLaughlin. I'm sure glad the committee can reunite you two today as we are. So this is great. Mr. Barrett, you've got the floor for 6 minutes, sir. Go ahead.
I'll start with you, Professor Stark. You've made comments that ethics rules should protect the public trust. I think that that's incredibly important when we're at a time with a public that sees their trust in democratic institutions and elected officials at all-time lows. We need to find ways to bolster public confidence. Would adding apparent or potential conflicts of interest to the Act close a loophole that currently allows compliance? And do you think that in doing so, it would address the concern that when the public currently sees a conflict, they feel like there's no action being taken?
I think that adding a clause mentioning or prohibiting the appearance of a conflict of interest is a good idea as long as it's understood what the appearance of a conflict of interest is. So if a conflict of interest itself arises when an official is in a position to affect their interests, even if they actually are uninfluenced by them, then the appearance of a conflict of interest is when they appear to be in a position where their interests could affect their judgment. So an example of that from the United States arose when the controller of the currency many years ago divested all his shares in federal banks, which fell under his jurisdiction. But he was accused of being in a conflict of interest because he still had shares in state banks, whose interests he could not affect in office, but it was deemed to be an appearance of a conflict of interest because the public might not make that distinction. So it's a finer notion, the appearance of a conflict of interest. But certainly, I think that officials have an obligation to avoid not simply a conflict of interest, but the appearance of such. Or to put it another way, their conduct should pass muster even with the most casual observer, meaning somebody who really doesn't pay great attention to the details, might misunderstand them, and his obligation is still to make sure they don't draw that conclusion.
To pick up on something that you said with respect to your example about the financial interests of these public office holders, it's been suggested that a prime minister could sell controlled assets and then have the proceeds reinvested by a trustee who is independent from and free from the direction of the public office holder. Why not do that?
That's I see no reason for not doing that. That's a way of resolving an actual conflict of interest. What you're describing is a blind trust where the office holder puts their assets gives them to a trustee, and the trustee is directed to liquidate them as soon as reasonable, that is, as soon as the trustee can find a buyer for them, and to reinvest them in instruments that the office holder does not know the identity of. Of course, it can take some time for the trustee to do that. So during the period before the trustee has managed to sell a particular asset, the office holder, especially if it's the Prime Minister or another senior office holder, should recuse themselves or be screened from any involvement with that asset. Once it's sold, then it's no longer an interest of theirs, and there's no reason for them to be recused from matters dealing with that asset.
When public office holders are screened from being involved in discussions or taking decisions on matters that put them in a conflict that could see them benefit their own financial interests, should there be public reporting that has occurred, so that there is that visibility again for the sake of public confidence that the system is working? The concept of it sounds fine, but the public doesn't have visibility on if and when it's used, and it might seem to strain. To strain most people's trust again if they hear that it's going to be employees of or appointees of that public office holder who are protecting them from that involvement, and that the decisions, if you had, the current Prime Minister, as the example I will use, has extensive holdings in a company that's invested in transportation and infrastructure and military and power generation, all things that certainly the head of government would touch on in their role. So the question is, do you think there should be public reporting of when the screen is used?
I think that's something that the committee should consider, and I would agree with it depending upon what we're talking about. As I understand it, the Ethics Commissioner has set up a screen, as you describe it, where two officials in the Prime Minister's office are going to divert issues that might be part of the Prime Minister's portfolio from the Prime Minister's attention. But I think if that's all that happens, that's not enough. That for example, the Ethics Commissioner should meet periodically with those two officials to review what they have done. Perhaps there are other more hands-on ways in which the Ethics Commissioner can be. Sorry, yes?
Yeah, I'm sorry, we're over time here, but
pardon me. Okay.
Maybe we can get back to it in a sec. Okay, Ms. Church.
Okay.
Ms. Church, 6 minutes, please.
Thanks very much, Mr. Chair, and welcome to you both. Professor Stark, maybe let me pick up on, you were talking a little bit about perceptions of conflict and debunking the assumption that conflict of interest somehow is akin to corruption. And I think that that's actually a very neat way of getting to the heart of one of the issues that we've been wrestling with. Do you believe that perceptions of conflict, when they're not grounded in evidence, can undermine public trust? And how should legislators ensure that perceptions do not overshadow facts?
I think that perceptions can undermine public trust. And again, we're talking about situations where there isn't even an actual conflict of interest, let alone corruption, but the appearance of one. And I think that a provision in the conflict of interest legislation that requires office holders to take care to not allow the appearance of a conflict of interest to arise is helpful. The difficulty or the pushback on that, just so that everybody knows it, is that that's a very vague provision. And it's not necessarily the case that an office holder, and I can think of cases that involve both conservative and liberal governments, but I won't detail them here, but where officials did violate what would have been an appearance standard had there been one, but it's also obvious that they might not have reasonably anticipated that that could have happened. So I think an appearance standard is important, but it's also important to make sure that the penalties that attach to it are appropriate, since there is a certain degree of vagueness attached to what it means.
Yeah, I would have to say I think that that's where we are struggling a little bit, is to understand how to define that and how to reasonably conclude in the minds broadly of the public, in some of the examples that you raised, how to anticipate what is an appearance in someone's mind. Seems like a very subjective determination to be made, that difficult to create boundaries in law to guide action. But maybe talk to me a little bit about, in your research, how important is it that conflict of interest determinations are made by independent institutions such as the Ethics Commissioner, rather than through political debate or partisan narratives?
Before I answer that, let me just say one last thing on the appearance issue. I am less concerned about a vague law or a law or a provision in the law that simply prohibits the appearance of a conflict of interest, as long as we understand and as long as it's well understood that we've moved very far from accusing the official of any kind of corruption. So it's something they shouldn't do, but it should be like a Claudette Bradshaw situation. Sorry, I can see that I may have done something that appears to be a conflict of interest. I've taken action to correct that. It wasn't actually a conflict of interest, and the other side says, "Thank you. That's well done." And that's basically how it should work, if it can in politics. And I don't know if it can.
I was going to say, I think we all want to aspire to our better angels, but we may find some challenges there. Maybe, David, let me turn to you in terms of your lengthy experience in governance and at various levels of government. Maybe could you describe a little bit about how you've interacted with conflict of interest frameworks? Do you have experience administering screens or working with people who had screens or trusts, blind trusts, when you were working in government?
No, I have no particular experience working on with screens or blind trusts. As a designated public office holder, when I was in the federal government, in Minister Flaherty's office, then as President and CEO of the National Roundtable on the Environment and Economy, I had to, fill out my own forms and declare any particular conflicts and file all that stuff away. So that's really been my only direct experience.
Do you have any advice for us then, as we're thinking about how to shape and amend our conflict of interest laws, and ways that you think, given your experience, that we could protect public office holders and protect the public trust?
A few things, if I could. I mean, the principle that I tend to work with from being around politics and governance for quite a while is what Ronald Reagan used to say to Mikhail Gorbachev: trust but verify, as opposed to verify but trust. It's you have to have a starting point for this, and I think if we want to rebuild and recalibrate trust or renew trust in our system, we have to start with some semblance of trust at the outset. But you have to verify that, and that's why we have conflict of interest codes, lobbying rules, and all the associated public hygiene, if you will, for our public sector. I would suggest you might want to consider or take a look at what's been happening in Manitoba recently. So again, no surprise from my experience there. There was a recent conflict of interest ruling against by the commissioner there against the premier and the former premier, former minister of finance, and former minister of the economy over violating the caretaker convention during the period between when the PC government lost and the NDP government was coming in. The conflict of the commissioner found that although there was not a private benefit to them, they had broken the rules and the law because they had ignored, if you will, that basic convention which governs our system, responsible government, etc. And the commissioner fined them. And the difference, a public fine of some, I think it was $18,000 in the case of the former premier, $10,000 or $12,000 for the former ministers. The act allows for up to $50,000. So that's not insignificant. And so I would urge you to look at the nature of fines, because I think it conveys a really strong sense of a view on the matter at hand.
Thank you, Mr. McLaughlin. Monsieur Thériault pour 6 minutes, s'il vous plaît.
Mr.
Merci.
Thériault, you have 6 minutes. Thank you, Chair. I'll start with Mr. Stark. I agree with you on the difference between corruption and a conflict of interest. It could happen that a person finds themselves in a conflict of interest, but they put themselves in that position, and the verdict could end up showing that there was in fact corruption. But we can't assume from the start that being in a situation where there is conflict of interest means being corrupt. It can be involuntary, and so ethics needs to be proactive. And I agree that ethics cannot be proactive, or if we want it to be as proactive as possible, we need to examine the matter of an apparent conflict of interest, or the appearance of a conflict of interest. If we want to educate elected officials, and we could tell them, not only should you not find yourself in a conflict of interest, you also should not find yourself in an appearance of a conflict of interest. So, if I'm looking out for an appearance of a conflict of interest, chances are I won't find myself in a real conflict of interest. So I agree with you on that. That said, for you and Mr. McLaughlin, have you had to manage an ethics screen or a conflict of interest screen?
I did not hear a translation of that, Monsieur Thériault, so I think I'm going to have to, I don't know if Mr. McLaughlin, my old friend, knows enough French to answer that question, and I don't know what to say about that, but for some reason...
Okay, I'm just going to stop you there, Mr. Stark. The translation was working fine in the room. I'm just wondering if you're on the proper French translation on your Zoom feed. That might have been it. Moi, j'entends le translation.
I am hearing interpretation in my earpiece.
On the English translation?
Well, I don't know, and
Okay.
I don't know where to find it here.
Okay.
And I'm sorry, I wasn't advised of this.
Yeah, I'm gonna suspend for a second, and we're gonna set you up here. Monsieur Thériault, je vais donner tout le temps après. Okay.
Mr. Thériault, I'll give you back your time after.
back to the meeting. Apologize, Mr. Stark, there was a technical difficulty. Mr. Thériault, tu peux commencer pour 6 minutes, s'il vous plaît.
Mr. Thériault, you have 6 minutes. Thank you. So I'll start with Mr. Stark. I was saying that I agree with you on the distinction that you made between a conflict of interest and corruption. I was saying that someone could find themselves in a conflict of interest without it being voluntary. And so that is why work is done by the ethics commissioner that needs to be proactive and not necessarily retroactive. That way one is not caught in a conflict of interest. And then there would be a sanction. But the commissioner might find that there is a case of corruption, and so an assessment needs to be done. But now we're talking about ethics needing to be proactive. It requires more than law, and rebuilding trust for me towards their institutions requires that we look at an appearance of a conflict of interest, and I agree with you on what you said. The ethics commissioner meets with an elected official, states that you cannot be found in a conflict of interest, but you should also not find yourself in an appearance of a conflict of interest. So if I am trying to be careful to not find myself in an appearance of a conflict of interest, chances are I won't involuntarily find myself in a conflict of interest. I would like to think that you would agree with me. You can answer yes or no on that. And then I have an additional question after that.
Thank you, Mr. Thériault. If you're saying that officials who take care to avoid even the appearance of a conflict of interest will necessarily also avoid being in an actual conflict of interest, I would agree with that. I also think, if I'm understanding you correctly, that it's important for public officials, and I'm sure the ethics commissioner would say this, for MPs and ministers, whenever they think there might be, they're not sure, an appearance of a conflict of interest in a situation, that they should ask the commissioner for their thought proactively beforehand, and not wait for and not simply do something and then find a retroactive adverse judgment. So certainly a proactive discussion, and that would include concerns about appearance as opposed to real conflict of interest, I think is important.
Effectivement.
I agree. In our legislation, and there is a code for members and for their behavior, and there's legislation for public office holders. Do you believe that there should be different rules for the Prime Minister? Let me explain. And I will also ask you whether or not you've had to apply an ethics screen. But anyway, the Prime Minister is the head of state, and when the Prime Minister decides that there isn't a conflict of interest, well, there won't be one. And the Prime Minister is going to be deciding who's going to be around the table. So there should be a moral authority there. There would be one for a minister, but not for the Prime Minister. Often it's subordinates, whether it be a chief of staff or clerk, that will say to the Prime Minister that he needs to recuse himself, or that would be responsible for applying this ethics screen. Currently, I think that the screen is not quite operational, and I don't understand its use. Have you, Mr. Stark or Mr. McLaughlin, had to apply an ethics screen. And do you agree that there should be rules for the highest role of the state? It requires being exemplary and transparent.
With respect to an ethics screen, no, I have not had to apply that in the political context. As a cabinet secretary in Manitoba, I had to manage recusals of ministers on policy matters for legal reasons, and that worked very well. Reflected those in the minutes. An ethics screen, it may be imperfect, but it's not illegitimate. I mean, it's a known technique, a known tool to use, and I think you want to give your commissioner as an independent officer, and I think you should be looking at how to strengthen the role and the tool and the sanctions that the independent officer has. But you need to give that person the tools to manage the diversity of conflicts that can come from 300 plus members of parliament and 40 member cabinet, et cetera. It doesn't mean that the individual is in an automatic conflict of interest. They've actually taken some steps to try to remedy that, which is the first thing. The step one is to actually remedy any potential conflicts by having the commissioner sign off on them. I'm not convinced that the Prime Minister or the Premier, in the examples I've been, really has to have an extra sanction, as long as or extra sort of layer, as long as they are sufficient and adequate for everybody.
Je parle pas de sanctions ici, mais on reviendra dans la conversation.
I wasn't talking about sanctions in this case, but we will come back to that. And Mr. Stark, would you be able to respond to the question? I know my time is up, but...
Yeah, thank you, Mr. Stark.
Okay,
we'll come back to it. We'll come back to it in a minute.
Okay,
If Mr.
okay.
Theriault wishes to, we're going to go to Mr. Cooper for 5 minutes, please.
Thank you very much, Mr. Chair. Professor Stark, you were quoted in a May 5th, 2025 article in the Financial Post stating that the primary remedies for conflict of interest are recusals, disclosure, and divestment. So just to clarify, you would consider these three to be the primary remedies of avoiding conflicts of interest?
Yes, I would.
Okay. Now, the Prime Minister has more than 500 reported conflicts of interest and 103 conflicts that are subject to the so-called ethics screen, conflicts related primarily to Brookfield. Now, it's the Prime Minister's position that decisions affecting Brookfield's interests wouldn't come to his desk, wouldn't come to his attention by virtue of the screen, but that isn't exactly true, given that the ethics screen only kicks in when a decision disproportionately impacts Brookfield's interests relative to other companies as part of a broad class. So consequently, that would give the Prime Minister fairly wide ambit to make decisions affecting Brookfield's interests, would it not?
Yes, and that is a terrific question, and it's one that I was going to suggest. It's one of two that I was going to suggest that the committee really should think about. The other being the involvement of the ethics commissioner beyond simply setting up a recusal regime, but continuing on. But the question of whether or not an official should be able to affect their interests if those interests are not disproportionate and are part of a broad class. That idea comes from American legislative ethics, and the idea is that if you're a legislator, you're voting on your legislation that's going to affect many people, not just you. And there are 400 other members of the legislature who are involved in the decision. It's not yours alone. Then it's okay for you to participate because you're being countered by others. It's been imported in Canada into our ethics regime for the executive branch, and I'm not sure it's legitimate to do that. But there is a pushback, which is if the Prime Minister can't even deal with broad issues that affect his interests co-equally with others, then we're getting into a situation where the Prime Minister is not able to really act in office. I've heard it said that the Prime Minister should simply liquidate his assets totally and put them in GICs or cash, But even then, of course, he can affect his own interests because he can affect in various ways the interest rate, etc. So some thought has to be given to where on the line from really disproportionately affecting your own interest to affecting your own GICs even, we should draw the line as to what constitutes a conflict of interest or not. And that's an important question. It's a philosophical question that I think the committee should wrestle with.
Now, do you think it's appropriate that the ethics screen is administered by, among others, the Prime Minister's Chief of Staff, who is answerable to the Prime Minister? Doesn't that create at least the perception of a potential conflict of interest?
I think that I think that what has to happen is that the ethics commissioner should be checking in regularly and reporting to Canadians, not the actual identity of assets, etc., but that they've checked in and that there were some issues here and they've been remedied, or et cetera. And if something serious did happen, then it's something the ethics commissioner should investigate. But it shouldn't. But I think the legislation, if you want my opinion, should require involvement of the ethics commissioner beyond simply setting up the blind trust, but beyond and then saying that's it, you guys go and manage it.
And as it stands, of course, the ethics commissioner isn't involved. He says, okay, Chief of Staff, you administer the ethics screen. We're supposed to trust the Chief of Staff and the Clerk of the Privy Council, both of whom are answerable to the Prime Minister, are doing this, but there is no reporting mechanism. There is really no information provided to demonstrate that the ethics screen is actually working. So would you agree that the Prime Minister, in the interests of transparency, should inform Canadians about how the ethics screen is in fact working on a day-to-day basis?
I would say that the Prime Minister could, and I think it would be a good move, voluntarily say that the ethics commissioner is being invited on a regular basis to review how the trust is operating, the screen is operating, and to make recommendations or to repair holes or to deal with issues that come up. And if he finds that a serious breach has occurred, that should be publicly known and it should be investigated.
Okay, thank you, Mr. Stark. Mr. Cooper. Mr. Saini, you have 5 minutes. Go ahead, sir.
Thank you. Mr. McLaughlin, as the Chief of Staff to Honorable Brian Mulroney, to your knowledge, did Prime Minister had blind trust or screens at that time?
I don't recall. It wasn't part of my remit or role at that time to manage any of that, any of his personal, ethical or financial issues. So I couldn't tell you honestly.
Okay. Mr. Stark, when officials, whether they are civil servant or serving the public, take an oath of trust, is that not enough for us to accept that this is what they're doing? If we don't trust civil servant or the politician, how do we run the country? How do we manage? Or do we say anybody who is successful in business should be excluded? And that's not how democracy should work in our country.
Well, I'll just refer to what David McLaughlin said, trust but verify. We should trust our officials, but it's important to have a conflict of interest regime and outside monitors to assist them. The ethics commissioner should not be seen as an opponent, but as someone who is helping and working with officials to establish trust. I don't think that a well-run conflict of interest regime should exclude people of wealth or who've done well in business from entering politics. There's no evidence that has happened in, for example, the United States, where until this current regime, which doesn't observe any of the conflict of interest laws excluded, where very wealthy people have found the privilege of serving in government worth putting their holdings in a blind trust for a while and haven't suffered, I don't think, financially as a result of that, or have recused themselves, then they can hold on to their wealth. They don't even have to get rid of it. Or if disclosure is the regime, they can hold on to their wealth. It's just disclosed. So there's no real inherent opposition between conflict of interest law and people from the business community entering politics.
Thank you. In your experience in Canada's current ethic framework, fundamentally sound, with reform best guided by evidence rather than political pressure or individual controversies? Mr. Stark.
I think it's fundamentally sound. I think that there are improvements that could be made, and I've suggested a couple of them, but I think the law is fundamentally sound. I think what the Prime Minister has done is fundamentally sound, but it could be better because the Ethics Commissioner could be more involved in monitoring the ethics screen, and there could be a better understanding of the matter of whether it's appropriate for the how we deal with matters where very powerful officials are affecting their own interests, not disproportionately, but as part of a broad class, but they're still affecting their interests. So that is a question that I think that the current moment with the current Prime Minister brings to our attention. It's not often that a very powerful official is also a very wealthy person in this country. Usually, wealthy people are not necessarily in the most powerful positions in a government, or the most powerful person is not a person of great wealth. But this is an unusual moment, but because of that, it allows us to address some of these questions that we wouldn't otherwise.
We have heard evidence from that Canadian ethics are very sound and they are on top of the world, other democracies. Is there any suggestion that you can make that we can bring from other countries or even from provinces that will make it better?
I'm sorry, Mr. Stark, a very quick response, if you don't mind.
Okay, it will be quick. I don't have any such suggestions. I'm not really au courant with provincial regimes, and I don't think, from my knowledge of American and British conflict of interest laws or regulations, that there's anything from them that I would suggest importing.
Okay. Thank you, Mr. Senet. Mr. Stark, Monsieur Thériault, je vais vous donner 5 minutes. Commencez, s'il vous plaît.
Merci. Alors, je voulais...
Thank you, Chair. I wanted to give you the opportunity to respond to my previous question, if you remember it, Mr. Stark.
Can you just very quickly prompt me on that?
Sur l'application des filtres...
Regarding the application of the conflict of interest screen, have you had to manage one or apply one?
No, I never have had to do that.
Est-ce que vous convenez avec moi qu'à partir du moment...
Do you agree that once the Ethics Commissioner receives a declaration from an elected official, he assesses it and decides that there needs to be the application of an ethics screen, it's because there is a potential appearance of a conflict of interest, and objectively, that individual could find themselves in a conflict of interest. Agreed?
Agreed. Yes,
okay.
Absolutely.
OK. Donc, à partir...
So, when we find ourselves in that kind of situation, I have a bit of an issue now. We're dealing with a specific case. There is an individual who worked for a company worth $1 trillion, controlling over 900 companies and having hundreds of personal interests. And the first thing that this person did after arriving in power was to implement legislation that would bring about major changes in Canada's economy. So the Prime Minister decides on Canada's economic orientation, and 5 industries that are impacted would have an impact on Brookfield. So does this not at least seem to be an appearance of a conflict of interest? And this legislation is supposed to be in response to a trade war that should be solved by 2026. Perhaps there will still be issues after that, but the projects will take 8 to 9 years to start on the East Coast, if I can use such an expression. But I would like to know how we could deal with such a case. Even if we're told that we can't focus on specific cases, this is creating a precedent. And so, is there the appearance of a conflict of interest, even objectively? I'm not trying to look at this subjectively.
We're back at the question of when the Prime Minister engages in debates over legislation or regulation or policy that affects whole industries or the entire economy, but therefore also affects his own interests as a result. And I'll go back to the observation that there are 3 remedies for conflict of interest: recusal, divestment, and disclosure. In some of the cases that you are talking about, he can't recuse himself because he's the Prime Minister and he has to be involved in these issues. Maybe he can't divest himself either, and maybe the blind trust hasn't found a buyer for those interests. In those cases, disclosure is what we're talking about. And in fact, there is de facto disclosure. You just articulated it. The Prime Minister is involved in massive policy decisions that affect interests of his as well as those of many other Canadians. So as a Canadian, you and I can judge whether or not we think the Prime Minister's judgment was biased. And we can weigh that in our vote at the ballot box and in our assessments of how he's doing. In the absence of recusal and divestment, which may not work in this case, disclosure has to happen. But we sort of have it de facto.
Mais ma préoccupation est à l'effet qu'on ne peut pas dire.
But my concern is that we can't say that a decision with a general impact won't have an impact on that individual's holdings. I can put my assets in a blind trust, but does that mean that the Prime Minister doesn't have to recuse himself in 99% of cases because our legislation only focuses on something that has an impact on one's personal interest? Could we not consider that there are some general impact matters that could lead to a potential conflict of interest?
I agree, and I think that is something the committee, that's one of the 2 main issues that I would suggest the committee wrestle with. But I also think that we're going to come to a point where if the Prime Minister is going to be able to exercise their office, disclosure is really the only, and they can't get, and they haven't been able to divest their holdings and put them in, GICs or whatever, or in stocks, the identity of which the Prime Minister doesn't know. Until that happens, he can't recuse himself from everything. So disclosure, it has to be the remedy. But this is an issue that you should wrestle with.
Thank you, Mr. Stark. Merci, Monsieur Thériault. Mr. Barrett for 5 minutes, and then Madame Lapointe. Oh, Monsieur Sarré après pour 5 minutes. Mr. Barrett, go ahead, please. 5 minutes.
Mr. McLaughlin, I'm curious about the fines and the recovery of fines in the context of the Manitoba example that you gave. First of all, the upper limits of the fine, whether or not this is an order of the commissioner, or if it's a recommendation to be voted on by the assembly? And also, what is the effect of the order? Is it does it become a provincial court order or a federal court order? So is it enforceable? And in doing so, if it does become an order of a court, does it then survive things like prorogation, for example?
A recommendation from the commissioner to the Legislative Assembly. The Legislative Assembly has a debate on it and votes on it. In this case, there was a unanimous agreement by all members that, in fact, to accept the report of the commissioner, which included these particular fines. The commissioner explained in the report his sort of how he triaged the fines. An upper fine for the premier, former premier, she received the highest fine on that, and then less for the somewhat less for the other individuals. The sanction beyond the public sanction and public embarrassment, if you will, litigating this in public for these individuals was that the government could withhold or garnish, if you will, any outstanding wages, pensions, and other kinds of payments that they were entitled to. So if they did not pay the fine, then the government could take steps to basically say, okay, we'll withhold a portion of your pension or whatever we owe you for other things until it is paid off.
Do you think that it would enhance were these powers given to the federal commissioner? Do you think it would enhance the separation or enhance his or her independence? Should they have the power to impose the fine without simply recommending it to the House and then thereby politicizing the matter further?
I think it's a good question. I think a cleaner version would be for the commissioner. If you're going to have a truly independent commissioner with that kind of authority, then to give the commissioner that, the appropriate authority through legislation, et cetera. That takes it out of the political cockpit, however legitimate that debate is in terms of a vote in the House of Commons and with all the attendant, drama, if you will, or that goes with it. It makes it very clear that it is not, in fact, a political issue. It is, in fact, a conflict of interest issue, and here is the particular fine and sanction, and then it has the appropriate force. I don't know how you write that in law, but I think that would be a cleaner way of doing it.
Quickly, if you could, do you believe that fines of the magnitude of $50,000 for violation of the Conflict of Interest Act for serious violations of it are an appropriate remedy for breaches?
I would, whether it's 50 or 100 or something, I mean, a higher fine definitely carries more weight. It says to the public, this is important. This is, if there's a mistake here, people say, well, wait a minute, $50,000, that's a lot of money, right? So it must be important. It's so certainly a higher fine. You could scale it in some way depending on the extent of the offense. If there was money involved, I'm not certain again how you might do that, but I would certainly push it to an upper limit as much as you're allowed to in law.
Thank you, Professor Stark. Just quickly, would you agree with that type of regime having fines $50,000 to $100,000 depending on the office that's held and the offense or violation or contravention of the act?
I don't know I agree with David that it's serious to be in a conflict of interest, but again, it's not necessarily corruption. So I think that the best thing to do in a conflict of interest situation is for the official to have a chance to remedy it and to apologize and acknowledge it. But in cases where that doesn't happen, yes, I think there should be fines, and they should be significant. What the amount should be, I don't know.
Thank you, Mr. Stark. Mr. Barrett, Mr. Sari, pour 5 minutes, s'il vous plaît.
Mr. Sari, you have 5 minutes. Thank you very much, Chair, and thank you to the witnesses for being with us, one in the room and one on Zoom. It's a privilege to have you with us and I greatly appreciate you being with us today. I think that the questions that have been asked so far have allowed me to reflect further and to reflect on the goal of this committee. We would like to strengthen the public's trust. We know that trust can erode for different reasons, including because of perception with social media and things like that. My question is for both of you. Do you believe that a perception of a conflict of interest, when it is not based on facts, could undermine the public's trust? And should legislators ensure that these perceptions stay out of the political scene?
I believe very strongly in the political process. I'm not naive about how contentious it can be, but I think the public has a role here. And the public needs to hear these things, and so it can judge appropriately. And so an appearance of a conflict, if it's properly litigated politically, and that, I mean, the public will sort through it. So I trust the public in that sense. I think the trust there's a boomerang effect on members of parliament and institutions if it is pushed too hard, if it is, if it's clearly manufactured in some fashion. So we rely on members of parliament, rely on the institutions, the processes, to behave properly, if you will, to take this seriously. And if there's going to be a charge of or an assertion of an appearance of a conflict, and that's probably where this would amount to, because if it was an actual conflict, it would have been dealt with, would have been appropriate sanctions or remedies, et cetera, with the commissioner. So I will ultimately defer to the political cockpit, the political process for this, but it's incumbent on everybody to play their role appropriately and within a framework, so so the public can judge.
Thank you. That's a very good question, and there's been some debate about the appearance standard in the age of social media, because it's very easy now for political opponents and people who are just generally looking to stir it up to make allegations that amount to that create an appearance of a conflict of interest almost. And I think that is something that has to be considered if you're thinking about including in the legislation a provision regarding the appearance of conflict of interest. One of the things it suggests to me is that if an appearance of conflict of interest charge is raised in the context of a social media campaign against an official, that the commissioner has the latitude to say there was no appearance of conflict of interest here, but for the irresponsible allegations being made by certain social media outlets. So that is a perfectly legitimate way for the ethics commissioner to resolve an issue. And I don't know how you write that into legislation, but it's certainly a principle I think that should apply.
Vous avez raison, mais en même temps, ça pourrait aussi.
You're right, but this could have an impact on politicians as well. But I would like to come back on the Canadian model. So in a case where assets are known, rather, we have a similar process to other countries in Europe. Do you believe that our model could be qualified as being solid?
Are you asking me that question?
Yeah. We start with you, and after that, I can ask.
Okay. Yes, I think our regime is solid, for sure. It's gone through many evolutions. Some of them were less solid than they are right now. I think, though, that there are, and I think your discussions and deliberations have identified them, some areas where there may need to be some improvements. But basically, yes, it's solid.
Yeah, thank you, Mr. Stark. Merci, Monsieur Sarret.
Thank you, Mr. Sari.
For today, Mr. McLaughlin. Mr. Stark, I want to thank you for taking the time to be here today. Apologize for the little security delay, but delay of starting the meeting. I really appreciate the information that you provided to the committee, and on behalf of the committee and Canadians, I want to thank you for your appearance today. So we are going to suspend for a minute. We're going to go in camera. The meeting is suspended.